So yes, but as you know that not every fact will ultimately lead to a legal norm. Only some facts will. Okay, so whether certain acts would actually represent a legal norm, which is an ought. Okay, you cannot answer that simply by observing facts. Okay, it requires some kind of mental inquiry about what the facts mean. So there is an act of interpretation, applicable here. So mere reading something will not convey it. Okay, you also have to interpret. Okay, so there's a mental process involved here. Okay, and that will make you understand the law in the normative sense of the term. Okay, so that's what this idea of norm essentially is. Okay, now norms, as you know, for Kelsen, norm could have like many different meanings. Okay, so but there is a central idea. Okay, you could have. So at this stage, I'd like to introduce you that we have been using the word norms in a very generic sense of the term. Okay, that there is some element of ought that is involved here, but when Kelsen is talking about law in the legal sense. Okay, the way in which he's using the word norm is much more specific than the way we use the word norm generally. Okay, so he says that norm is the meaning of an act by which certain behavior is commanded, permitted, or authorized. Okay, now this is still very general. Okay, saying that what is norm? Norm is the meaning of an act. So it is not the act itself, because act lies in the physical world. So there has to be a meaning. So there's a world of ideas, or there's a world of oughts. Okay, so he's saying that norm is the meaning of an act, okay, by which certain behavior is commanded, permitted, or authorized. Okay, so for example, a particular law says that you shall not harm someone physically. Okay, a particular, if you read particular provision of the statute, that's what it says. Okay, now what you find in the statute book, okay, in itself is a description of what you see in the real world. Now that's not the norm. Okay, norm is something else. It's the meaning that you attribute to it. So here the particular provision of the law says that, okay, you shall not kill. Okay, now you see that even the statement is in that form. Okay, that you shall not kill. Other day we were talking about the definition of murder as is provided in Indian Penal Code. So it's, you will see that even when you look at the law, it is not in the ought formulation. It's not in the ought formulation. It essentially describes certain facts, okay, which are prohibited by the law. So yes, it seems to be the fact. Okay, so that's not the norm. Okay, so what is the norm? It is the meaning that you give to the facts that you have seen here. Okay, it is the meaning that you give to it. That's what the norm essentially is. So so if the law says that you ought not, you shall not. Okay, so if it says that hurting someone, okay, physically assaulting someone is prohibited. Okay, the norm that you derive from is that you ought not to harm someone, you ought not to assault someone. So that's the meaning that you derive from the norm, from the fact that you see in the acts or in the decisions of a particular court. So that's essentially what is being talked about by Hans Kelsen. So yes, now the thing is that one specific feature of law that we discussed earlier, okay, was that laws take the form of rules. Okay, they take the form of rules, and one thing that is special about rules is that rules are rules are general in nature. Okay, they are applicable. They have this general applicability, and they have prospectivity in their application. Now this is something that is not this is something that you do not find in the works of Hans Kelsen. Okay, so for him, law in the sense of norm, okay, may take the form of specific rule, may take the form of a rule as well as that of specific command. So it does not have to be general. Okay, so for example, an example which has been given is that a traffic officer, okay, orders you to stop. Okay, that command is given to one specific person. Okay, now this is not general, so you cannot say that this is an example of rule. This is a case of specific command. Okay, so even though this is specific to one individual, nonetheless it is a case of a norm. Now that's not the end of the discussion. Whether it takes the form of norm or not will be answered by certain other things that we need to discuss. Okay, we cannot ignore that, but for now just imagine that, okay, the traffic police, okay, officers police officer orders you to stop at the traffic. Okay, that's a norm because it is validated by another norm. Okay, now what is that, we will discuss in a while. Okay, but even though the order here is very specific towards one individual, that does not make it any less normative, is what Kelsen is talking about. Okay, on the other hand, any law which is generally enacted by a particular legislature, whatever the law is general in nature. So you can say that it is a case of rule. Okay, so both these are normative in nature. Okay, so both are accounted for in the work of Hans Kelsen. So in his philosophy, he does not really make much distinction between specific orders addressed to individuals and the general rules as you find in legislation. So yes, that's what you see. Along with this, another factor that is lacking or not important in the works of Hans Kelsen is the prospectivity in law. Okay, so you need not know the law beforehand for it to be considered as law, as long as the command here, okay, even if it is retrospective in nature, is validated by a previous norm. Okay, not previous norm, like superior norm, you can say that, well, that's a case of a valid norm. And if we are talking about legal norm, then you can say that, well, that's a case of valid law. So yes, that's the idea of norm. But at this stage, understand this, okay, this in continuation of what we just discussed, it is this, that not every command, not every expression of will be considered as a norm. Okay, be it in the moral sense or in the legal sense. Okay, Kelsen is not yet making the distinction between legal and moral. So this applies both to the legal norm as well as moral norm. So he says that not every expression of will directed to a person is a norm. So you have to now sieve off that which constitutes a norm and that which does not. Okay, so remember the example that we had taken, that a gunman points a gun at your head and asks you to hand over the wallet, and we will have difficulties in saying that, well, the gunman's demand constitutes law. And then it is also backed by a threat of sanction in the form of the gun being pointed at your head. Okay, now we have tough time, difficulties in saying that this is a case of law. Whereas when tax collectors demand that you pay tax, okay, that is considered as a valid law. So what is the difference between these two situations? Well, the difference, if you remember for Hart, okay, he would say that there is something that is missing here, that is the internal aspect. Okay, but for Kelsen here, he's saying that, well, the robber's action here is not validated by another norm. Okay, so whether I ought to obey the command of the robber, if that were to constitute a norm, it has to be validated by another norm. Okay, that is lacking. Whereas in the case of the tax collector's demand, okay, there is a norm. Okay, and we consider that as a valid norm. Now, the validity, with respect to validity, there are two different things that you need to understand. Okay, so there is a subjective meaning of a particular act, and there would be something called objective meaning. Okay, so he's saying that the subjective meaning of two acts, okay, the two acts that we just discussed, okay, the gunman demanding the money and the tax collectors demanding money, the subjective meaning of both these two things are the same. So that is something we are not able to understand in the theory which has been given by John Austin, because he did not bother explaining us this. Okay, so Kelsen is trying to help us. He's further saying that each wills that I hand over the money, both the tax collector as well as the robber. Okay, but only the latter, that is only the latter, that is the demand of the tax collector, okay, has objective meaning in the Kelsenian sense. Okay, it is objective because an antecedent valid norm authorized the demand. Okay, so there could be many different such demands which are made, but not all such demands will be considered as valid. Only the ones which are validated by a preceding norm. Okay, if it is validated, then you would say that, well, it is objectively normative. Okay? If it is not, then it's just subjective. Okay, so that's something that is very important. So this is something which was not explained by John Austin. H.L. Hart tried to explain it to us through his idea of internal aspect, okay, internal point of view, that it is not just one way projection of authority, as is the case with the robber, but there is also this element of some kind of reciprocity, but he just does not go far enough. Our other philosopher, Lon Fuller, takes it further. But here in case of Hans Kelsen, he is talking in terms of, are you able to hear me? Are you able to hear me now?
Yes, sir, you are now clearly audible, but a moment before your voice was cracking.
Okay, I'm sorry, because I'm at home, I'm on leave, and I'm using the the internet connection from my mobile. So yeah,
can you please repeat whatever you said?
Which portion can you tell me exactly where you lost me?
Subjective meaning of validity.
Yeah, so see, we discussed about two examples. Did you hear those two examples? One is the gunman demanding you hand over your money, and the other one, the tax collector demanding money from you.
Yes, sir.
You did?
Yes, sir.
So between these two, one is norm, the other one is not a norm. Okay, can you tell me which one is norm and which one is not norm?
The tax collector.
The tax collector's demand is norm, and gunman's is not. Okay. Now this distinction would not be possible in the works of John Austin. Okay. Why is that? Because he's not talking about the law in terms of norm. Okay. But our philosopher Hans Kelsen is talking about it in terms of norm. Okay. So for one to constitute a norm, the other one not to, there has to be some difference between these two. And what is this? Okay. So there is a subjective meaning and there is an objective meaning. So in the first case, okay, you see that the subjective meaning of both the acts, okay, be it the robber's demand or the tax collector's demand, are the same. They are demanding something from you. So subjectively they are the same thing, but objectively they are not the same. Why is the latter not objectively the same? Because the tax collector's demand for money is validated by another norm. Okay, so that's the difference here. So I hope I was able to make the distinction clear here. Okay, the gunman's demand is not validated by another higher norm, whereas the tax collector's demand is. So for example, the tax collector is authorized under a certain statute. So what is the norm with respect to the statute? The statutes, the law which has been laid by the statute ought to be obeyed. Okay, the law authorizes the tax collector to demand that you pay money. So because the law says so, you ought to do that. Okay, why should we follow? So if you go further, why should I follow what the legislation says? Well, the legislation has been enacted by the legislature following the proper procedure, okay, following the proper requirements. So what is the norm there? Well, the laws enacted by the law, legislature following all the procedures, okay, ought to be obeyed. Okay, so you see that one act is, okay, in the subjective sense is validated by another. Okay, the one which is validated is the norm, the one which is not validated is not a norm. So that's essentially what the idea is that Kelsen is talking about. Okay, it is norm, okay, if it is objectively, okay, objectively valid, okay, because subjectively they convey the same meaning, but for it to be objectively true, okay, I should not say true because that's what you talk in terms of in the factual world. Okay, so the one that has objective meaning in the sense that the one which is validated by the preceding norm is the norm that exists. Okay, so that's the idea that Kelsen is talking about. So did I make sense? Was I audible? And if I was audible, did I make sense? Hello? Am I audible?